Go ahead.
Hi, I'm Vivian Dempsey, and we're going over PTA from the Winter 2015 bar exam. We're on the third issue, which is the escrow holder's duty once he's placed on notice that there is either a mistake or a conflict between the parties as to the escrow instructions. And this is the Diaz case. In the Diaz case itself, the issue, the facts of the case were that there was a typo, essentially. There was a mistake in the amount of the sale price. Okay, our situation is not a mistake, and so we're going to be analogizing that the same rule should apply in our facts. In our situation, our client Chris Connors is aware that the deal has crumbled. It's fallen apart. There's a dispute now between the buyer and the seller, and the seller wants to revoke the offer and to cancel the deal. Okay, until both sides have signed all the papers, it's still fluid, and that's where we are in the transaction. Essentially, Virta says you didn't close when you said you were going to close. I've lost all confidence in this. I don't think you have the money to do this. And, I just want to revoke. Okay. And our client has notice of that. Okay. So under the Diaz Rule, which is actually about mistake, the court says that in that circumstance, the escrow holder can do one of two things. He can continue to hold the property and hope that by holding it, it will give the parties a chance to talk with each other, to negotiate, to settle, come up with a new deal, and update the joint escrow instructions. The other thing that he can do is interplead. He can put the property before the court, the trust property before the court, and let the court sort it out. So those are the two courses of action. What he cannot do is just go ahead with the deal. Okay. We already know that, and unfortunately, that's our client's motivation here. Okay, conversion is the tort. We've already talked about that in the other case, but in this case, Diaz goes further and says punitive damages are permitted when the action of the defendant, who's our client, when the action of the defendant is malicious or fraudulent, or of evil motive, or in conscious disregard of others. Okay. Well, here's what our guy did. Okay. All right. Remember that our side wants to delay the closing. I might not have said this before. Our side wants to change the payment schedule. Okay. This is a lot of money. And they want to spread out the payments over a longer period of time than what was originally agreed. Okay. The two documents that need to be signed by both parties are the transfer agreement, and the transfer agreement makes reference to the payment schedule. Payment schedule is not included in the transfer agreement. It's a separate document, but the transfer agreement makes reference to it. Okay. Our side has asked Chris, our attorney, to change the terms of the payment schedule. It's a different document. Okay, it's no longer the same document than what was agreed to. Okay, and he says, hey, it's no problem because it's not referred to in the payment schedule. So if they both, in the transfer agreement. So if they both sign the transfer agreement, no problem, because they just refer to this separate document that I have altered. So they basically, the two sides did not sign the same agreement because our guy changed the terms of the payment schedule, which was referred to in the transfer agreement. Okay. And he didn't tell anybody he did that. He just said, here, sign the transfer agreement, and didn't indicate that the terms of the deal had materially changed. Okay. So I would say that what our guy did was conscious disregard of the interests of others, the other being Virta, which means that not only will, if our guy closes the deal, will he be guilty of conversion, but he will be subject to punitive damages for what he did. Okay, so that's what you get out of the Diaz case. So this is all the information that you have. Now what you're going to need to do in our next video is to pour this into the format. And we'll do that in the next video.